Hi ladies and gentlemen, today we have Mr. Prashant Khurana with us and the topic of discussion would be the same-sex marriage that's taking place before the Honorable Supreme Court. And
The marriage is not taking place.
the marriage is not taking place, I'm sorry, the arguments are taking place. The arguments are taking place before the Supreme Court on the topic of same-sex marriage. So yeah, but that would be something in itself, right?
Yeah, we'd hope.
Yeah, we do hope.
I think they can do this once they finally approve it. If they do,
Mhm.
the first marriage should get registered for the Supreme Court.
I think that should. Would be something
That'd be a strong message.
Yeah. But yeah, no, talking about the legal arguments and just whether the Supreme Court has the ambit and the scope to actually adjudicate such a big issue. What are your views, Prashant? Tell us more about the developments that have been happening since the last 5-6 days.
I think everyone broadly understands the arguments. So I think first we need to look at what is the nature of the construct within which we are placing all of this. Right? So marriage as an institution, it evolved socially long back in the times. There's references in the Arthashastra, for example, that Chanakya wrote, why do you need marriage? The reason for that was that you wanted people to settle down so that they could be productive within society, and it was easier from a settled population to extract revenue. And one way to get people to settle down is to make sure that they exist in multiple groupings so that no one person can wander off anymore. I think all of that practically today has lost its relevance, to be very honest. Because you no longer need people to be in a certain place to have productivity, you no longer need them to be in a certain defined household for you to tax them. So what's remained out of that institution is essentially the significance that we attach to certain benefits that we ended up offering to that institution. So when America's Swami, for example, says that you have nomination rights associated with it, you have bank account opening privileges associated with it. All of those are benefits that the state gives. So as somebody who identifies as a social libertarian, I think there is no reason for the state anymore to have more of a role in the institution of marriage than a simple librarian, which is to record that a person has gotten married, and that's about it. But somewhere in the evolution of this institution, we started giving more and more role to the state to define what the institution is supposed to be also. To say that it is supposed to be a union between a man and a woman. You had religious institutions that came in and demanded this, and the state then codified it. And that's where I think the problem in the present construct lies for the Supreme Court, right? If they go ahead and say that, fine, same-sex marriages are permitted, they'll not only be undoing the construct of how marriage in India is recognized, and I think very few people appreciate this fact. In India, marriage is not recognized as a civil union as it is, say, in the US or in other Western democracies. There's a religious aspect associated with it. In fact, the current arguments are discussing marriage more through the construct of the Special Marriages Act. But even that was enacted more to make sure that there were interreligious and intercaste marriages. So even when going to define interreligion and intercaste marriages, you use the construct of religion in the first place, or caste in the first place. So you're still placing that institution within what society, say 2000 years ago, understood marriage to be. And that is, I think, where the fundamental problem lies, right? And that makes me skeptical, even though I would want the state to move away from this front. That the Supreme Court could, from interpretation of the Constitution or the Special Marriages Act, could go on to say that even the Special Marriages Act can at least recognize same-sex marriages. Because if the very inherent construct of that act is to say that we are only doing this to recognize interreligion and intercaste marriage, then at max what the Supreme Court can do is say that, okay, within the framework of this act, you will have same-sex marriages. But that creates another problem that if a Hindu wants to marry a Hindu or a Muslim wants to marry a Muslim of the same sex, they can't do that under the Special Marriages Act today. In fact, they can't do that even if they're of different genders as of how the Special Marriages Act stands today. So that's a problem, right? They'll have to do that within every single religious law. And that makes it very difficult to do without parliamentary backing being there in the first place. So I think that's not to say that you shouldn't allow it. I think the way to do that, and if the Supreme Court were to grant some sort of legitimacy to same-sex marriages within this legal construct, I think what they'll end up having to do, and that's the only conceivable way that I see of this, is to do something like they did with living relationships, which is to recognize them as a civil union of some sorts. Extend all the benefits of marriages in tangible terms that you understand to same-sex marriages as well. Now, what legislation do they read this into? I frankly don't have an answer to that.
Just coming to the legislative part of the definition of a person or a people, or the fact that there is the definition of sex. So for now, let's say that there are 3, 4, 5, 6 sexes. There is male, there is female, there is, prefer not to say, there is transgender, which was recently recognized. I would find it difficult to actually go and amend all these legislations with that term, because as the Solicitor General had mentioned, the definition of being fluid. If I am today a man and tomorrow a woman, how do you legally sort of counter that argument that if I want to change my gender, the whole abstract of gender definition gets sort of changed? What are your views on that?
It's a good argument from the Solicitor General's perspective in that it places a lot of administrative burden on the state. But that's not a reason to deny somebody the right, because it's not the government that is deciding for a person as to whether you'll be a male or a female. Your job is to look at that on a sheet of paper and then decide what sort of benefits you get as an individual. So just because it places a burden on you, it can't be the case that you'll not allow a person to do this. This will be like behaving like one of our banks, right? You want to take a loan, it's difficult to take that loan, so we'll not give it to you. That's not how this works. So it's a good argument from an administrative perspective. And I also to an extent agree that somebody, if they wanted to, could try and misuse this in some form. But that's not a reason to say categorically that this right cannot exist. Frankly, so long as privacy is recognized as a right, and these are facets of privacy ultimately, how you live, what sort of bodily autonomy you have, etc. These are undeniable facets of privacy. You can't, on a categorical basis, say that I will not allow this because there is this administrative burden. You'll have to find workarounds of that burden. And frankly, that's not the job of the court to do. An honest system which were working perfectly, which, to be very frank, I don't see this government being, in at least the central part of it, the union government functioning, would say to the court that okay, if we were to lose this case, we will come up with rules and regulations to fix all of this. That they would not be making these arguments to stop the court from making the categorical pronouncement so long as the constitutional aspect of that right is concerned. And nowhere in the world are these arguments made, to be very frank. If you look at the arguments that were made in the US Supreme Court, for instance, on the same issue, nobody raised these arguments because these are irrelevant considerations. This is only something that is, I would say, unique to the way Indian jurisprudence has evolved, that lawyers can come up and make these sort of arguments, which I frankly don't agree with, because an administrative hurdle cannot be the basis of you saying that I will not give you a right.
Talking about administrative hurdles, the BCI, the Bar Council of India, recently came out with a letter which sort of condemned, the idea of same-sex marriage, which was followed up by the Supreme Court Association condemning that letter, which was followed by another letter which was written by several judges, retired judges and civil servants and bureaucrats and top officials and former ambassadors as well. So I think this issue is picking up a lot of heat in terms of the stakeholders that are involved, and there is a lot of pressure as well as what do you say? There's pressure as well as there's a lot of traction that is sort of being gained. Where do you come in terms of what the role of the Bar Council of India should be, being an autonomous body? The role of the Supreme Court Bar Association condemning that letter of the Bar Council of India, and then the recent letter of those several judges, former judges and bureaucrats and ambassadors coming in and writing to the President of India to not, make sure that, because the President has the power to sort of overrule anything ultimately. If the President wants, he can sort of, he or she can just go ahead and make that put that stamp and say that okay, this is what is best for the country. So what do you say about that?
No, I think in terms of gaining traction, like any social issue, it's healthy that people are coming out and giving their views. But so far as And that's to do with how civil servants, etc., have written to the president. Now, one objection I have to that and one clarification there, I don't think the president has the power to decide what the Supreme Court chooses or chooses not to hear. So, if they want to write to the president, they may, but that's not the correct institution to write to. If I were objecting to this, I would have written to the Chief Justice of India. I don't know what they were trying to achieve by writing to the president, but okay, that's their right. They can write to whoever they want to. But so far as institutions such as the Bar Council, the Supreme Court Bar Association, I would say they are within their right to have views. They are within their right to publicly express those views. But the problem is that when you're such a large institution, you need to take into consideration the fact that you're not only speaking for yourself or whoever's sitting within those 10, 12 member governing boards. You're speaking for every member of the institution, which would you and I qualify as well, so far as at least the Bar Council of India is concerned. And the problem that I have with that letter is not its contents. That's up to them to choose what they want to write. In any democracy, they should have that right to say what they want to. But the fact that the other people who are within the Bar Council were never consulted before that letter went out. So, had they done a public vote of all lawyers who are registered in the country to ask whether they are fine with it, and if a majority supported it, they went ahead and wrote that letter, absolutely fine. But that never happened, right? So, if you're writing as the Bar Council of India, you're giving it the credence of that office, that institution. And that creates a challenge because not everyone within that institution has accepted it. Or either you say that these are views of the members of so XYZ members who happen to be in the Bar Council at that point of time. So I don't have a problem that much with the views. I may disagree with them, I may agree with them. And it's good that people are expressing it. In fact, they should be filing amicus briefs also with the Supreme Court. It will help the court make its decision if they want to. But I do have a problem with institutions going ahead and making statements at an institution level without discussing with the members there. And that goes same for the Supreme Court Bar Association. I don't know how that decision was made, but I hope that when they did write criticizing that letter, they had unanimity at least within the association.
So I think we've sort of broadly covered the aspects that have been dealt with. Any final thoughts which sort of come to your mind with respect to this institution of why there is so much backlash, especially in the Indian societies? Because I would say there is a certain stigma, even at the time of when the 377 section was sort of taken, and the decriminalization of LGBTQ took place. There were, I remember, protests, and there were. It wasn't a very, celebratory sort of. I mean, obviously the sects that were affected, they sort of came out and celebrated it. But then in the Indian system, although it's actually ironical because when you go back to the Hindu mythology, there are deities and characters belonging to the Hindu mythology who were engaging in homosexuality back in the day. So
that actually goes to the point of marriage being a younger institution than Hindu mythology itself. So that also tells you something. The fact that it was acceptable earlier within even Hindu society, which has tended to be very conservative over the recent past, tells you that it's the institution of marriage which is conservative, not Hindu society per se.
Makes sense. So, any closing remarks which you would like to address to our viewers?
I think one thing we still need to consider is it's fine. I mean, the phrase of Raghumanyu comes to mind to say that Indian democracy is a reluctant democracy in that sense, and we have been. So, decriminalizing homosexuality was one aspect, which was to say that, okay, we will let you exist. That's basically what we said.
Yeah.
And we will not throw you in jail for being the way that you are. But when it went to extending the practical benefits that any normal citizen in India has, we haven't really gotten there also.
We have.
As of today. Maybe in some urban circles here in Delhi, in Bombay, maybe people accept it, but larger society doesn't really accept it as much. So that's obviously a problem, and I think given how large this country is, it is going to take a while for those attitudes to change. That's fine. But what we do need to understand is that this case then goes to the heart of catalyzing that debate, and that's why you see so much backlash, because marriage as an institution is very front and center in India, right? Everyone knows you go abroad and speak to any Indian, whether or not they've had any connection with India, the very first thing they've seen is a marriage in a Bollywood movie, or at least they've come and attended somebody's wedding. So, as an institution, it's very front and center in how our society plays out. All our social customs, they're centered around this institution. How you pray, who prays at what point of time, most of your festivals, the role of people within those festivals is all centered around household being headed by a couple, and then that couple having other people around them who go and perform various tasks. So that backlash is to be expected because there is going to be quite a significant churn in how that institution is currently structured. Mm-hmm. And to an extent, Marx's classical theory of gender division of labor also applies to the marriage institution very, very clearly in an Indian household, regardless of religion, by the way. So all of that will go for a toss if this is accepted, right? And so that amount of churn that you can expect. What you can't expect, and this is where I think it's a very sort of a strange conundrum that we are seeing, especially with this court. This is a court that's been criticized in the past for not taking up very, very important constitutional matters, right? For kicking the can down the road. We know about Kashmir, we know about the sort of UAP cases that have been pending for so long, the CAA case, for instance. And yet this court has oftentimes found the opportunity to hear what would otherwise be characterized as socially liberal causes, right? And that's good, obviously, for the people within them. But what we also need to understand, and this is more to predict how this court is going to react on this case, is that I don't think since Shreya Singhal, which was back in 2013, we've had a firm ruling of this court where a tangible remedy has been provided against the state. And that's what's making me very skeptical about this case going the way we would want it to go, which is that same-sex marriages should get legalized. Because whatever's happened since then on these socially liberal cases, and we can go one by one, on homosexuality, for instance, all that you did was decriminalize it. Anyway, there were very few prosecutions there, so there was no tangible impact as such that went against the state. In Anurata Bhasin's case, when internet was almost recognized as part of free speech and a fundamental right, that judgment ran brilliantly for 98% of its content. The last 2% where you wanted to have an operative order, it didn't say anything. It just asked the Home Ministry to form a committee. So the executioner was made the judge and the jury again in that case on restoring internet. It never went anywhere. So no remedy given, even though you had a broad pronouncement. Privacy, input to Swami, very, very nice abstract understanding of what privacy is supposed to be. Never really went anywhere when it came to overruling Aadhaar, 6-1 decision in favor of Aadhaar. Yeah. So I think there is this trend that this court particularly has tended to make broader pronouncements on abstract concepts, but when it comes to the lived reality of giving a tangible remedy, it has shied away. And this unfortunately looks like a case where you will have to give a tangible remedy. Yeah. And if that trend is to go by, I think we can see where it will land.
Do you think if the Supreme Court was made as a constitutional court and there were court of appeals for every high court, the Supreme Court would have that sort of frame of mind and bandwidth to sort of, tackle these issues with those tangible sort of outcomes?
I don't see how that changes anything, to be very honest, because if you see currently how the roster is divided, there are certain judges who are anyway only acting as constitutional courts. Because the roster is divided such that the Chief Justice and the senior most judges are hearing only writ petitions. Yeah. And everyone else is hearing appeals from High Court. So, in effect, you already have that structure, right? You're just not calling it in that name. The frame of mind has to be of the people who are sitting in those institutions. So, if the Chief Justice is only hearing writ petitions and very, very important constitutional interpretation questions, then you should have that frame of mind. So, I don't see how making a separate body or a separate building will change anything. Because in effect you've already done that.
Yeah. That's all folks for today, and thank you so much Prashant for taking all the time and coming here on this episode of Candid with RMT. Till next time, ladies and gentlemen.